Good morning, good afternoon, good evening, everyone. So I'm making this video on the light that there is an incoming typhoon. So if ever that we will not be able to meet, I can still uh, discuss through this video what you need to learn before your prelim exam. So uh, last meeting, just before your quiz, we finished discussing about the general provisions of partnership. So we've learned the basics of partnership, how it is created, and what are the instances of partnership and what are the kinds of partners. So now let's go on to the rights and obligations of partners. So let's start with the first category under this topic, uh, the rights and obligations of partners among themselves. So we have here Article 1784 of the Civil Code, which states that a partnership begins from the moment of the execution of the contract unless it is otherwise stipulated. So when we read the provision, it says there that the partnership life begins from the moment of the execution of the contract. And the execution of the contract, okay, is when the actual contributions promised by the partners of themselves have been actually contributed. So, uh, this is the time when the actual contributions are made. So, iba yung forming a partnership wherein both parties agree or they have a meeting of the minds as to the constitution of the partnership. That is different. The partnership is perfected from that moment, but the partnership life begins only upon the execution of the contract. And speaking of the execution of the contract, if, for example, that the partnership agreed that such partnership contract will be executed, let's say 1 year from now or 2 years from now, it should be in writing that is in accordance with statute of frauds, meaning that all agreements that involve more than 1 year or more than 1 year should be in writing. It does not necessarily mean that it should be in a public instrument. Kahit private document lang yan, pwede. Basta it should be in writing. Ibig sabihin, let's say for example, A, B, and C agreed that they will execute the contract or they will start their contributions 1 year from now. It should be in writing. Bakit? Kasi kung hindi po yan in writing, the contract becomes unenforceable. Alam niyo naman sa obligations and contract nyo, there are four kinds of contract. You have there the valid, the void, the voidable, and the unenforceable. It becomes unenforceable. Okay, so if it involves more than 1 year, okay, to be executed, it should be in writing. Otherwise, it is unenforceable. Okay, next, Article 1785. This is when a partnership for a fixed term, we have discussed previously na kapag fixed term or particular undertaking, pag nag-expire yung term or yung na-achieve mo yung particular undertaking, the partnership is automatically dissolved. So, if it is continued after the termination of such term or particular undertaking without any express agreement, the rights and duties of the partners remain the same as they were at such termination, so far as is consistent with the partnership at will. It means that the partnership, even if it already expired or that the undertaking has already been achieved and the partners continued the operations of the business or the partnership also continues. But take note that it is no longer a partnership for a fixed term or a particular undertaking. It now becomes a partnership at will. Kasi nga, in the beginning, it's a partnership for a fixed term or particular undertaking. Pag na-achieve mo na yung undertaking or nag-expire, dissolve. Kapag tinuloy, there is an implied agreement that the partnership will continue. However, the partnership is already a partnership at will. And if partnership at will na siya, anyone can dissolve anytime, di ba? Kasi wala siyang term. So, it becomes solely existing based on the will of the partners. So, yung buhay ng partnership nakataya na sa partners. Okay? A continuation of the business by the partners or such of them as habitually acted therein during the term without any settlement or liquidation of the partnership affairs is prima facie evidence of a continuation of the partnership. Okay? If the routinary transactions of the business or the ordinary operations of business are continued, or those that are habitual acts of operation of the business is continued despite the expiry of the term or the achievement of the particular undertaking, that continuation is already a prima facie evidence that the partnership has been continued. And there are examples that I've seen as provided by case law. Okay? So number one, where the partners borrowed substantial amount of money to launch an enterprise, and there was an understanding that the money would be repaid from the partnership profits. So since there was an understanding that the money would be repaid from partnership profits, even though the partnership has already expired, it means that the partnership presumes that it will continue its operation kasi you launch an enterprise and you are expecting to repay that loan through your partnership profits. It only means one thing, that you are continuing to do business. Okay? Number two, where one partner loaned this co-partner money to invest in the partnership with the understanding that the money would be repaid from partnership profits. Of course, okay, this is an ordinary transaction between co-partners. Okay? Hindi naman bago that there are times wherein you have to contribute to the partnership, and kapag wala pa yung isa, you can lend to another. Okay, that is, and the agreement is, or the understanding is, that the money would be repaid from partnership profits. So same siya dun sa number one, that is with the view that the partnership will continue to do business. Kasi yung pinaloan, let's say for example ni A sa co-partner niya na si B, okay, is mabayaran daw through partnership profits. So there is an understanding that the partnership will continue to do business. Number three, where the parties entered into a joint venture to build and operate a motel until it could be sold upon favorable and satisfactory term. Okay? So this is a partnership agreement, joint venture, to build and operate a motel until it could be sold upon favorable and satisfactory term. Kahit pa merong term lang yung benta nila ng motel, okay, if later on subsequently nabenta nila, there is still a partnership. They cannot say na wala ng partnership. Kasi nga, both of them build and operated that motel. Okay? So, under contributions of, under obligations of partners among themselves is to contribute capital. So, under capital, dalawa yan. It could either be money or property. So, let's go first with property. If a partner promises or stipulated to contribute property, he should contribute such. Okay? It is not necessarily naman kasi na at the moment na nag-agree kayo, doon na kayo magbibigay ng contributions nyo. Kaya, sineset nila yan usually at a later day. Okay, yung iba nga, di ba, 1 year. O, ganun. So, if that happens and the time comes that you should deliver the property that you have promised and you fail to deliver that property, the partner becomes a debtor of the partnership. Why? Because he obligated himself to contribute a specific property and he failed to do so. That's why the partner becomes a debtor of the partnership. 2. To answer for eviction in case the partnership is deprived of the determinate property contributed. Okay? Let's say for example, you promised to deliver either a building or land or a car, and then you did so. You did deliver that building or that land or that car. And all the while, during the partnership life, okay, let's say 3 months in, that car or that land was suddenly taken. Kumbaga yung mga hinihila na sasakyan. Basically because you found out later, the partnership found out later that that car was a mortgage by the partner and he failed to make his loan payments. Kaya hinila yung sasakyan. So in result, the partnership is evicted of its ownership and use of that car. Kasi hindi pa pala fully settled yung obligation dun sa car. Evicted, ibig sabihin, the partnership has been ripped off of its ownership and possession. So, liable ngayon si partner na nag-promise na i-deliver yung car or your building or land or whatever na pinramis niyang i-deliver. Why? Because the law on warranty applies to a partner. Okay? Therefore, if you promise to contribute a land, a building, or a car, or any property, you warrant that that property is yours. Okay? You're saying that this is my property, I will contribute it to the partnership. Okay? Meaning you will pass the ownership from you to the partnership. How can you pass that ownership if in the first place hindi ikaw yung owner? So, kaya merong law on warranty. Anything na ibebenta mo, law on warranty also applies in sales. When you are going to sell something, you are warrantying that that thing that you are selling is yours. Kasi hindi mo mabenta yan kung hindi sa'yo. Okay? Except yung mga agents. Okay? That is another thing. Okay? So, kapag na-evict yung partnership, the partner who promised or who delivered that thing is liable to the partnership. Okay? To answer to the partnership for the fruits of the properties, the contribution of which he delayed from the date they should have been contributed at the time of actual delivery. Okay? This happens, let's say for example, you formed a partnership engaged in transportation or delivery of goods, sabihin mo na lang. And your end or your promise is that you are to contribute your delivery van or your delivery truck to the partnership. But come the time na, let's say for example, dumating na yung time na dapat i-deliver mo, you failed to deliver, you only delivered it after 30 days. Okay? You shall be liable for the fruits caused by that delay, of the possible fruits or the lost income that you should have acquired due to that 30 days delayed. So, the damages will be computed kung let's say for example 30 days. Ilan yung profits na hindi nyo nakita because of that delay. Okay? Aside from contributing the property, you shall be liable for the fruits that the property could have earned. Okay? The fourth one, under obligations and contracts to preserve said property with the diligence of a good father of a family, pending delivery to the partnership. Of course, if you promise to deliver a car, okay, na in a good condition, hindi naman pwede na porket i-deliver mo siya sa partnership in 30 days, hindi mo na siya aalagaan. Hindi mo na siya i-maintain. Diba? You should maintain it. Okay? Ganun din naman pag nagbebenta kayo, 'di ba, ng properties, dapat maayos. Okay, to indemnify partnership for any damage caused to it by the retention of the same or by the delay in its contribution. This one, you can connect this one to the third one. Okay, with regards to the fruits. Kasi yung from the time that you are supposed to deliver until the time of your actual delivery, okay, there is delay. And from that delay, there is a loss na potential profits that you could have earned if na-deliver siya on time. Yun yung i-indemnify mo sa partnership as damages. Here, when you contribute your property, the partnership becomes the owner of the property contributed. Hence, the partner who contributed that property cannot withdraw or dispose that property without the approval or consent of the partnership or the other partners. Kasi nga, hindi na ikaw yung may-ari nun, kahit ikaw pa yung nag-contribute nun. Kung sabi mong ito-transfer mo yung ownership mo sa partnership, hindi na ikaw may-ari nun. Hindi mo na siya basta-basta pwedeng kunin, hindi mo din siya pwedeng ibenta or ipasangla. Okay? Because you are not the owner anymore. Now, what happens when a partner fails to contribute the property he promised to contribute? First, sabi natin kanina, the partner becomes a debtor of the partnership. Paano? Because of the partnership contract, di ba? You create an obligation. Okay? From that partnership contract arises an obligation on the part of the partner to deliver that property. Other partners cannot rescind partnership contract by reason of default in contributions. The remedy instead would be specific performance with damages from the partner who defaults. So, the remedy is not to rescind, but the remedy is to file an action for specific performance with damages. Of course, bakit specific performance, sir? Kasi promising to contribute a property or specific property is an obligation to give. Okay, that is an obligation to give. Hindi naman yan obligation to do. Diba? That can violate your right. Kasi kung hindi mo ma-deliver, of course, one way or the other, you are going to deliver either in its value with damages or you deliver the actual property with damages. Okay? In case of eviction, as we have discussed earlier, the partner is liable either to contribute another property. Kung wala naman ng other property na ganun, na same as pinramis, he can give the value of that property. Okay? In cash. Okay? In case of failure to perform services, I know that this is not property, but let's just discuss. Okay? You cannot file for a specific performance. Why? Because of your right against involuntary servitude. Okay? You cannot be compelled to do things that you don't consent of doing. Okay? Hence, sir, di ba sabi mo kanina kung property, kung hindi maibigay na yung property, money na lang. How about dito kung hindi maibigay yung service, pwedeng money na lang? No, cannot be valued. Why? Because in effect, you are treating that industry or service or effort as compensation. Okay, and generally, a partner is not entitled to compensation. But they can agree to that. Pero yun ang rule. It cannot be valued. Okay? Next, valuing contributions. When the capital or a part thereof which a partner is bound to contribute consists of goods. So this article speaks of goods. When goods are property pa rin ang goods, di ba? When they are contributed, ito lang kasi yung usually these are the things that you are going to sell, goods. Dapat daw ma-appraise siya. They should be appraised. How? There are two manners of appraisal. Number one, in the manner prescribed in the contract of partnership. Lagi niyong tatandaan guys, when we're dealing with partnership is a contract. Therefore, the parties can stipulate whatever they want. As long as it is not contrary to law, uh, morals, public policy, okay? Pwede silang mag-stipulate. So, kung may stipulation regarding appraisal ng goods, yun ang masunod. Ngayon, paano if wala? If wala, it shall made by experts and at the same time, according to current prices. Okay? So, hindi ibig sabihin na expert sila, they can just give appraisal value to goods that is not according to the current prices. Okay? So, take note, manner of appraisal. Okay? If merong agreement, yun ang masunod. Or may stipulation na prescribed sa contract. If wala, it shall be made by experts chosen by the partners themselves and according to current prices. Obligations with respect to money. So we're done with obligations of property, of contributing property. What if ang pinamis is money? Okay, of course, if you promise to contribute money, you contribute money. Okay, if pinamis mo mag-contribute ka after 30 days, you have to give it after 30 days. Okay? What if hindi mo na ibigay after 30 days? Okay? You will suffer, you will be liable for interest and damages. Interest because of the delay, and damages because of the delay. They are two different things. Okay? To reimburse any amount he may have taken from the partnership and converted to his own use. Okay? Kapag, let's say for example, you are entitled to keep the money of the property. So let's say for example, ikaw din yung cashier or ikaw yung naghahawak, sa'yo nire-remit ng cashier yung pera. Okay, kapag in the moment na ginamit mo yung pera na yan for your own personal use, hindi for the benefit of partnership, okay, you have the obligation to contribute that money back. Siyempre, ibalik mo, hindi sa'yo eh. That is partnership money. That is not yours. You have to give it back. Ngayon, kung gaano mo katagal maibalik yun, you are liable also for the interest and damages. Okay? Ang concept lang naman yun, once you contributed money, it becomes partnership money, di ba? Pag-aari na ng partnership yun. It is no longer used. Kapag kinuha mo yan, inangkin mo yan, that's not yours. There's only an implied trust. Okay? You are only a trustee of the partnership. Kapag ginamit mo yan sa personal use, you have the obligation to reimburse or to give it back to the partnership. Pag na-delay ka sa pagbalik ng pera na yun, you are liable for interest and damages. Okay? Gaya nga ng sabi dito, ito na pala yun, to pay for the agreed or legal interest if he fails to pay his contribution on time or in case he takes any amount from the common fund and converts it to his own use. So, you are liable for interest. Okay? And for damages, to indemnify the partnership for the damages caused to it by the delay in the contribution or conversion of any sum for his personal benefits. When we speak of damages, hindi damage to property yan, ano yan, hindi damage na sira or anything. Damages in law is what we call money. Okay, you are liable to pay money. That's why you have to indemnify. Babayaran mo. Yun yung damages. Basta pag narinig nyo ng damages, money po yan. Money obligation. Hindi siya damage to property. Pag damage lang narinig nyo, yun, damage yun. Pero pag damages sa law, money yan. You're liable for money. Okay? We spoken earlier of an instance wherein a partner used the partnership money for his personal use. That's what you call misappropriation. Okay? Now, if there is a fraud in that use, you could be liable for estafa. Okay, you could be liable for estafa. Like, for example, you failed to give notice to your partners that you have used the partnership money for your personal use, and lumipas na yung ilang araw or ilang buwan, ilang taon, hindi mo pa rin sinabi sa kanila, you could be liable. That is different from mere failure to return the money. Let's say, for example, ikaw yung managing partner, sa'yo niremit yung pera, ikaw ang nag-uwi sa bahay nyo. Although, dinadala mo ulit siya sa office kapag papasok ka. Ngayon, nagkataon na hindi ka nakapasok the next day. Ngayon, nagsuspetsa yung partners mo na baka nagamit mo na sa iba or anything kasi hindi ka pumasok. The next day, pumasok ka and binalik mo. That is only a mere failure to return it. Okay? Iba kasi yung estafa, which is a misappropriation to other personal use. Okay? So, the next one is to maintain the trust and confidence given unto him by his partners. This is what we call the fiduciary duty. Paulit-ulit ito all throughout this topic. We will encounter these situations. Okay, each partner must observe utmost good faith, fairness, integrity in his dealings with the other partners. So, dito kasi nakarely ang partnership. Kaya nga lang sabi natin, dun sa first chapter, you are acting for the common interest or for the benefit of the partnership, for the benefit of your co-partners. Hindi lang ikaw ang iisipin mo. Okay? Each partner cannot directly or indirectly use partnership assets for his own benefit, carry on a business of the partnership for his private advantage. Of course, gaya ng sabi natin kanina, yung paggamit dun sa personal money ng property, that cannot be. Kapag kailangan mong ibalik yan, liable ka rin for interest and damages, di ba? To carry on a business of the partnership for his private advantage. Okay? Imbes na kapag nakakabenta ka, imbes na niremit mo yung kita sa partnership, hindi mo pala niremit or hindi full yung pag-remit mo, meron kang mga sales na tinatago, that is carrying on the business of the partnership for his private advantage or taking any profit secretly to obtain for himself anything that he should have obtained for the partnership. Let's say, for example, that the partnership is looking for a lot or lupa. Okay? And ikaw, meron kang nahanap na lupa na very feasible, very strategically feasible for your partnership. Okay? At very interesting yung price sa'yo. Naisip mo na ikaw na partner, imbes na sabihin mo sa kanila, sa akin na lang, wala naman siguro akong obligation. Diba? Sa tingin mo, wala naman siguro. Kaya, ikaw nang bumili. Okay? Later on, the partnership found out. Okay? You could be held liable for that. Why? Because that is a business opportunity. You are aware that they are looking for a strategical lot for the partnership. And nung nakahanap ka, nung meron kang nakita, imbes na dinisclose mo sa partnership, you did not disclose it. You took it upon yourself na ako na lang ang bibili. You are liable. To carry on another business in competition with the partnership, he cannot avail himself of knowledge or information which may be properly regarded as the property of the partnership. Now, this one we will elaborate. Okay, there are two rules under prohibition to compete with the partnership. The first one, if you are an industrial partner, okay, Take note, industrial partner, you are to contribute your efforts, your service, or your work. Therefore, you cannot engage in any business. Take note, any business, unless expressly permitted by the partnership. So, general rule, industrial partner ka, you cannot engage in any business. Unless there is a stipulation that permits you to do so. Unless pinayagan ka ng partnership. What if, with that prohibition, you still engage in any business, kahit hindi pa same line ng business ng partnership mo? Can you be made liable? Yes. The capitalist partners have two options. Number one, they can remove you from the partnership with damages. So, tanggal ka na nga, magbabayad ka pa. Oh, di ba? The second option, so these are exclusive options. They can avail of the benefit you obtain from the other business with damages. So, kung capitalist partner ka, nag-engage yung industrial partner na partner mo into other business, kahit ano pa yan, pwede mo siyang ipatanggal with damages, or pwedeng lahat ng profits or benefits na obtain nyo dun sa business na yun, magiging part of the partnership property plus damages. Okay? Kaya anong sabi natin kanina, hindi pwede yung specific performance because of the right against involuntary servitude. Okay? The next rule, kung capitalist partner ka naman, kanina industrial partner, any business hindi pwede. Kung capitalist partner ka naman, you cannot engage in other businesses that are in the same line of business as the partnership. So, pwedeng mag-engage ang capitalist partner as long as it's not in the same line. If it's in the same line, hindi pwede. But, may exception na naman, unless otherwise stipulated. So, if in the partnership contract, capitalist partners are allowed to engage in any business, okay, sinabi dun any business or on the same line of business, pwede siyang mag-engage yung capitalist partners. Ngayon, what if with that prohibition, he still engaged in a business that is in the same line with the partnership business? Okay? Here are his liabilities. He may be required to contribute the profits he derived from the other business into the common fund. So, all the profits that capitalist partner earned in that other business, okay, shall be contributed to the partnership. In case of loss, kunwari, hindi loss sa partnership, in case of loss in the other business, he shall bear it alone. Wala, labas dyan ang partnership. Di ba? Nakipag-compete ka nag-engage ka pa sa other business na parehas naman sa atin alam mo naman na bawal. O ikaw, mag-suffer ka. You lost. Okay? Or he can also be removed from the partnership. Of course, hindi naman pwede na lahat yan. Parang dun sa una, generally two options. Either ibigay mo yung profits na earn mo dun sa business, dun sa partnership, or you can be removed. Okay? Now, other contributions with respect to capital. The general rule, okay, partners must contribute equally unless otherwise stipulated. Don't be confused by this provision. Ang ibig sabihin lang nito, okay, kapag merong agreement ang partners with regards to what they will contribute, yun ang masunod lagi. Diba? Paulit-ulit. Kung may stipulation, yun ang masunod. Yan ang tandaan nyo. Kung may stipulation, yun ang masunod. Kung may agreement sila, yun ang masunod. Kung wala, equal ang contributions. Kaya kung sabi ni A, B, and C, na mag-contribute si A ng 90%, si B ng 5%, si C ng 5%, okay, ng capital, that is okay. Kasi there is a stipulation. Kung wala silang ganun na agreement, under the law, dapat equal yung contribution. Okay? Okay, another instance na magko-contribute ang partners ng capital. In case of imminent loss of the business of the partnership, partners must contribute additional capital to save the venture. Now, this is a necessary duty or obligation of a partner. Take note, a capitalist partner usually. Okay? Why? Because of the imminent loss. Why? Because this imminent loss could endanger the partnership. Baka magkaroon ng losses which will result into the closure of the partnership. Kaya merong necessity. Tandaan nyo, may necessity to save the business. Kaya dapat mag-contribute ang partners ng capital. Sir, paano kung ayaw ng isang capitalist partner na mag-contribute? Okay, kung ayaw niya, he shall be obliged to sell his interest to the other partners. Why? Because the partnership is already on the verge of closure and you need additional funds or capital in order for the business to stay afloat. And the partner who deliberately refuses to do so shall be obliged to sell his interest to the other partner. Why? Because you are no longer carrying the best interest of the partnership. You are no longer acting for the common interest of the partnership, di ba? In the verge of closure na yung partnership, ayaw mo pang mag-infuse ng capital, ibenta mo na lang sa partners. Umalis ka. Ibig sabihin, umalis ka na lang. Ganon yun. Ibenta mo na lang yung interest mo para yung partners na lang magtutuloy nung partnership. Kasi you are no longer in the same page eh. The partners are saving the partnership while you deliberately refuse to do so. Why? Diba? Ibenta mo na lang. Diba? You are saving the partnership. Kaya ang sabi ko kanina, this concerns the capitalist partners. Kapag industrial partners ka, hindi ka na liable under this provision or under this instance. Why? Because you already contributed your industry. Maybe you have done enough. Baka stress ka na para lang magka-break even or mabuhay pa ng konti yung partnership di ba? Baka ikaw lahat ang nagtatrabaho doon, di ba? So, hindi na liable ang industrial partner. Okay? Okay. Application of collections. There are 3 rules under this provision. So, number one, we'll go with the first rule. But before that, you have to take note dun sa opening statement ng law. If a partner authorized to manage, it gives you a clue already that sino ang concern dito? Yung managing partners or those partners that are authorized to manage. So kung nabasa nyo sa problem or sa case na hindi siya managing partner, hindi ito ang mag-a-apply. Okay? Hindi ito ang mag-a-apply. So this rule only applies to managing partners. Una mo na yun, tandaan nyo yun. Ngayon, kung nakita nyo na managing partner yun, okay, sige. Ito ang mag-a-apply. Collects a demandable sum which is owed to him in his own name. Ibig sabihin, let's say for example, A, B, and C. Si A daw yung managing partner, meron siyang pautang kay, let's say for example, kay X. In his own name. Ibig sabihin, personal credit. From person who owed the partnership another sum also demandable. So ibig sabihin, itong pinautangan ni A na si X, partnership debtor pala din. Ibig sabihin, si X meron din siyang utang kay partnership. So nagets niyo yung scenario, ito. Si A yung managing partner, si ABC yung partnership, may pautang si A kay X. Si X naman at the same time, meron din siyang utang kay partnership. So parang si A, parang dalawang katauhan niya, di ba? creditor siya ni X. At the same time, siya yung representative ng ABC as creditor, hindi ni X. So parang ganun ang kinalabasan. The sum thus collected shall be applied to the two credits in proportion to their amounts, even though he may have given a receipt for his own credit only. Okay? Now, let's go to the rule para mas maganda. Okay, ibig sabihin, kung ano yung binayad ni X kay A, in this case, 2,500 pesos, must be applied proportionately sa utang ni X kay A tsaka kay partnership. Ibig sabihin, let's say for example, may pautang si A na 2,500 kay X, may pautang din si partnership kay X na 2,500. You get the proportion or the percentage, 2,500 divided by 5,000, 50%, 2,500 divided by 5,000, 50%. So, yung 2,500 na na-receive ni A, kahit pa inisyo niya yan for his own receipt or on his own name, okay, it must be applied proportionately between the two debts. So, 1,250 or 50% ng 2,500 na binayad pupunta kay A, yung 1,250 mapupunta kay partnership. Okay? Yun po yung first rule. What is the second rule? But should he have given it for the account of the partnership credit, the amount shall be fully applied to the latter. Meaning, kung imbes na nag-issue siya ng receipt para sa kanya, nag-issue siya ng receipt for the partnership, ibig sabihin, binigay niya daw, imbes na i-apply sa kanya yung na-receive niya na payment, sa partnership na lang daw i-apply. In that case, pwede. Why? Because it is for the benefit of the partnership. Okay? So, yung 2,500 mag-a-apply buo sa partnership. Third rule, the provision of this article are understood to be without prejudice to the right granted to the other debtor by Article 1252. Okay? But only if the personal credit of the partner should be more onerous to him. Ibig sabihin, itong article daw na ito, itong buong article, without prejudice to the right granted to the other debtor by Article 1252. What is Article 1252? He who has various debts of the same kind in favor of one and the same creditor. So, magkaiba naman yun. Yung isa creditor si ABC, yung isang creditor si A. Yes, but in that case kasi, A is acting like, is acting in two personas. He's acting for his own credit and is acting on behalf of the credit of the partnership. Kasi siya yung managing partner. So, this article applies. Kung sino daw yung may utang dun sa one and the same creditor, he may declare at the time of making the payment to which of them the same must be applied. Ibig sabihin, si X daw, pwede siyang pumili kung kanino mag-a-apply yung utang. In this case kasi, dun sa first rule, walang sinabi. Basta nag-head lang si X ng 2,500. It's the same with Rule 2. Kaya ang nangyari, kapag walang sinabi si X, okay, in proportion. Kung nag-issue ng receipt si A na para sa kanya lang. Kung kung walang sinabi si X, kung para kanina yung utang, pero ang sabi ni A, nasa partnership na lang isa-set off sa partnership buo. Pero in the third rule, kung sabi ni X na yung obligation ay na yung payment niya na 2,500 para sa utang niya kay A, pwede yun. But, only if the personal credit of the partner should be more onerous to him. Ibig sabihin, mag-a-apply lang ito if more onerous yung pautang nung partner ni A. Okay? Ibig sabihin, mas burdensome daw. In this case, the obligation to A bears 20% interest per annum, while the obligation to ABC bears 5% per annum. So, in this instance, mas malaki yung interest ng pautang ni A kaysa dun sa pautang ni partnership. Therefore, in this case, mas onerous yung pautang ni A. So, kung sabi ni X na A, magbayad ako ng 2,500 pero ito yung utang ko sa'yo, pwede yun kasi mas onerous, mas burdensome yung utang ni X kay A. If, for example naman na pagbaliktarin natin ito, ABC yung 20%, A yung 5%, okay? Tapos sabi ni X na, sa'yo, yung utang ko sa'yo ito, yung 2.5. Hindi pwede. Kasi, in that case, hindi na mas onerous yung utang ni X kay A. Mas onerous yung sa partnership. Okay? Okay. A partner who has received in whole or in part his share of a partnership credit when the other partners have not collected theirs shall be obliged, if the debtor should thereafter become insolvent, to bring to the partnership capital what he received, even though he may have given receipt for his share only. Okay? For example, si X, meron siyang utang kay partnership ABC in the amount of 4,500 pesos. Now, X was able to pay 1,500 to A. So, si A daw ang nag-receive. A issued a receipt for his own, for his share, for the amount of 1,500. So, meron pang remaining na 3,000 na utang si X. Now, later, X became insolvent. Now, if that happens, the credit of partnership, yung remaining 3,000, hindi na nila makolek kay X because X is already insolvent. Now, what happens? And bakit parang unfair? Kasi si A, na-receive niya yung 1.5 niya, si B, yung share nila, hindi nila ma-receive. Ang sabi ng law, kung ano yung na-receive ni A as his interest shall be contributed to the partnership. Okay? So yung 1.5 na receive ni A shall be contributed back to the partnership. Yung 1.5 ang paghahatian nila. Okay? Why? Because X is already insolvent. There is no hope in collecting that partnership credit. Okay? Every partner is responsible to the partnership for damages suffered by it through his fault. You have to take note of that. The first statement, let's put a bar on that. Yan muna. Every partner that is responsible to the partnership for damages suffered by the partnership through his fault shall be liable. Of course, he who caused damages shall be liable. Okay, basic concept. And he cannot compensate them with the profits and benefits which he may have earned for the partnership by his industry. So, hindi niya pwedeng sabihin na yung industry ko na lang as a set-off. Okay? Kasi nga, parang balik tayo dun sa una, parang binibigyan mo na naman ng value yung industry mo which may look, which may translate as a compensation which is not allowed. Okay, so hindi pwede yun. However, the courts may equitably lessen the responsibility if through the partner's extraordinary efforts in other activities of the partnership, unusual profits have been realized. So, if a partner caused damage to the partnership, he shall be liable to his fault. Can he offer as payment his industry? No. But if he can exert extraordinary effort, take note, extraordinary effort, and that extraordinary effort resulted in an unusual profits, the court can lessen his liability. Okay? Paano? Let's say, for example, let's adopt this example. Naging insolvent na si X, di ba? Yung sabi natin kanina, may 3,000 pa na utang, pero since insolvent na siya, uncollectible na yan. So, ang gagawin ng accountant ng partnership dyan, i-write off na yan. Ibig sabihin, you can no longer collect the money. Ngayon, what if yung partner na nagkasala or nag-cause ng damage dun sa partnership was able, out of the blue, to collect the 3,000 pesos from X? That could be what you call extraordinary efforts and which resulted in unusual profits. Kasi nga, the act of writing off a debt, parang sinasabi mo na kasi na we can no longer collect this. this is already a loss for the partnership. Okay? So, tinabi mo na yan. Wala na yan. Ngayon, kapag nakakolekta out of the blue si partner na liable dun sa debtor, that could be considered as unusual profits. Who bears the risk of loss of things contributed? You have to take note, this principle is the same with principles in obligations and contracts. Whoever is the owner bears the risk of loss. Precisely like that. Okay, so ang titignan mo, ownership. So kung sino yung owner, siya yung may risk of loss. Ibig sabihin, if masunog, ma-destroy, mawala, yung property na yun, ang liable lang dun is yung owner. So ownership equals risk of loss. Okay? So if what is contributed is specific and determinate things which are not fungible, where only the use is contributed, meaning only usufructuary rights or use are contributed, meaning the ownership remains with the partner who contributed the property. It means that the risk of loss is borne by the partner. Why? Because the ownership is not transferred. Okay? So, yun ang titignan mo, ownership. Specific and determinate things, the ownership of which is transferred to the partnership. Of course, if the ownership is transferred to the partnership, sinong may-ari? Partnership. The risk of loss is borne by the partnership. Kung fungible things, it is borne by the partnership. Kasi consumable yan. Malamang kapag binigay mo na yan sa iba, kukonsume niya na yan, siya yung may-ari niyan. Siya na yung may-ari niyan. Okay? Things contributed to be sold. Partnership. Of course, if you are contributing goods, di ba? That will eventually be sold to your customers, to the customers by the partnership. That is already partnership property. Therefore, risk of loss, partnership. Things brought and appraised in the inventory in the absence of contrary stipulation. Anything that is appraised in the inventory, di ba? Merong mga properties that should be appraised, di ba? Like immovable property, di ba? Building, land. Okay, they must be appraised in the inventory. Now, if that building is burned, okay, to the ground, okay, the one who bears the risk of loss is the partnership. Okay? As long as that the ownership is transferred to the partnership. Tandaan nyo, basta hindi lang use yung kinontribute. Kung building talagang kinontribute, partnership na may-ari niyan. Kapag nasunog yan, partnership na ang mag-bear ng risk ng loss. Okay? However, claim shall be limited to the value appraised. Of course, kaya mo nga siya in inventory in the first place, gaya ng goods, gaya ng real properties, because in case that property is lost, burned, destroyed, or can no longer be used or sold, ang claim lang dyan is limited to the value appraised. Yun yung basis mo lagi. Okay? Responsibility of the partnership. The partnership shall be responsible to every partner for the amounts he may have disbursed on behalf of the partnership and for the corresponding interest from the time the expenses are made. It shall also answer to each partner for the obligations he may have contracted in good faith in the interest of the partnership business and for risks in consequence of its management. There are two rules that you need to observe here. The first rule, yung first part ng paragraph, okay? The partner shall be liable for the amounts he may have disbursed on behalf of the partnership and for the corresponding interest. Meaning that if there is an expense that needs to be paid by the partnership, okay, and the partner took it upon himself to pay it kasi nga siguro urgent, okay, the partnership is liable to him. Kasi yung partner na yun, since walang pera yung partnership, siya muna ang nagbayad ng expense or ng kahit anong obligation ng partnership, the partnership is liable to him. Okay? The expenses are already incurred by the partnership. Take note that under the first paragraph or the first phrase, okay, there is already an existing obligation. Walang kinontract si partner. Siya lang yung nagbayad lang siya out of his own pocket for the benefit of the partnership. Okay? Let's say for example, kuryente. Bayad ng kuryente ng office ng partnership, walang cash yung partnership, siya muna ang nagbayad. The partnership is liable to him. Kahit hindi niya in-inform yung partners. Okay? However, if the partner contracted obligation on behalf of the partnership, yun na yung ibang istorya. Okay? Kasi dun sa first phrase, the partnership did not contract any obligation. Okay? He merely disbursed his own money for the sake of the partnership. Siya lang yung nagbayad ng expenses that was already contracted. Okay? But in the second phrase, okay, it was the partner himself who contracted or who created that obligation for the partnership. Kaya dapat yung yung pag-contract ng obligation na yun must be done in good faith. If it is not done in good faith, the partnership is not liable to pay the partner. Okay? In this example, ABC, C purchased goods out of his personal funds for the partnership without the knowledge of A and B. Later, ABC incurred the loss because of that purchase. Can C claim for reimbursement? The answer is no. C purchased goods out of his personal funds. Of course, mayroong nagamit na personal funds si C. But C contracted obligation. He purchased goods, di ba? So, ang i-apply mo dito yung second. Dapat in good faith. In good faith ba siya under that example? No. Kasi without the knowledge of A and B. Dapat i-inform niya. Pwede namang subsequent yung pag-inform niya. Pero kung hindi niya i-inform, that is not good faith. Therefore, may defense ang partnership dito? No. You acted in bad faith. We are not liable. Okay, you contracted that obligation by yourself, okay, without our knowledge. Okay, so you should see the difference between these two statements. Yung sa una, there is an existing obligation and the partner paid that obligation out of his own pockets. The partnership is liable. Kahit good faith, bad faith, kahit ano pa yan. Basta may existing obligation na. Okay? Kasi kahit gaano mo balikta rin yun kahit may good faith, bad faith dun binayaran niya pa rin yung obligation ng partnership Ang bottom line dun, nag-benefit yung partnership. Okay? Dun sa second naman, kung wala pang existing obligation, nag-create ng obligation yung partner, tapos yung partner na yun, kinuha niya yung sarili niyang funds pang-create ng obligation na yun, at nag-incur ang partnership ng loss, dapat in good faith yung pag-contract niya. If not in good faith, may defense ang partnership, bad faith. Diba? They are not liable for that loss. Okay, now let's proceed to rules for distribution of profits and losses. There are 3 to 4 rules here. Let's start with the first one. If there is an agreement, of course, contract ito. So, any agreement is binding, except if contrary to law, morals, public policy. Okay? Diba? The first rule, if there is an agreement as to profits and losses, it shall be controlling. Kung 60-40, 30-30-40, why not? Pwede. Second rule, if there is no agreement, okay, if silent, what shall be the basis of the profit and loss sharing? The basis shall be their capital contributions. Of course, hindi lang naman meron din naman partners na walang kinontribute na capital. Paano kung industrial partner? They shall be given a just and equitable share. Okay? That's the second rule. First rule, agreement controlling. Without agreement, it shall be based on their capital contributions. Ngayon, what if merong profit sharing agreement? Meron silang profit sharing agreement. However, there is no loss sharing agreement. The rule here is that the loss sharing shall be the same as that of the profit sharing. Okay? If there is no profit sharing, stipulated losses are distributed according to capital contributions, of course, tapos na yan. However, for losses to under net income, under net loss, kapag nagkaroon ng net loss, industrial partners are not liable. Okay, take note, iba ang net loss sa capital loss. Kapag net loss, hindi liable ang industrial partners. Okay? So, those are your rules. Agreement should be followed. No agreement, capital contributions to industrial partner, just and equitable share. Kung merong agreement but that agreement pertains only to profits, that profit agreement shall also be applied in case of losses. But industrial partners are not liable for losses. Ang losses dito in the concept of net loss. Okay? So, a stipulation which excludes one or more partners from any share in the profits and losses is void. Take note, a stipulation. Ibig sabihin, guys, that what is void here is the stipulation, the agreement. The partnership still exists. Partnership still exists. Except, paano kung dun sa may stipulation sila, in-exclude nila yung industrial partner na mag-share sa losses. Pwede ba yun? Pwede yan. Kasi nga, under the law, they are not liable for net loss or for losses. Okay? If the partners have agreed to entrust, this is the fourth rule under profit sharing. First, agreement. Second, wala capital contributions. Third, merong profit, walang loss sharing, follow mo yung profit sharing. Fourth, if they cannot agree as to the profit sharing, pwedeng mag-entrust to a third person ang mga partners. Why? To this, basically, hindi sila makapag-agree kung paano yung profit sharing. So, yung third person daw ang mag-establish ng profit sharing. Once that third person, okay, submitted the profit sharing agreement, such designation may be impugned only when it is manifestly inequitable. Only in the instances where the profit and loss sharing is manifestly inequitable. Let's say, for example, two partners A and B. Say, ang capital contribution niya ay 90%, si B 10%. Ngayon, hindi sila makapag-decide kung paano ang profit and sharing. Hinire nila si C na mag-establish ng profit and sharing nila. Okay, ngayon si C, ang sinabi niya, ganito ang profit sharing. Si A, entitled to 30% profit and loss sharing. Si B, 70%. Now, is that equitable? No. Kasi 90% yung capital contribution ni A, tapos ang sharing niya lang sa profit, 30%, tapos si B na 10% lang contribution, 70%. That is manifestly inequitable. Hindi naman may tatago yan na inequitable talaga. You can question that, you can impugn that. But, in no case may a partner who has begun to execute the decision of the third person or who has not impugned the same within a period of 3 months from the time he had knowledge thereof complain of such decision. Meaning, there is a period for you to question that decision. 3 months dapat i-question mo. If you remain silent or you executed that decision of the third person without any question, okay, you are barred. Hindi mo na siya pwedeng questionin. Basta up to 3 months lang, within 3 months lang, pwede mo siyang questionin. This applies to the principle that silence means consent. Okay? Na-receive nyo na yung decision, ikaw naman, aware ka na unfair, wala ka namang ginawa, nag-lapse yung 3 months, you can no longer complain. Okay? The designation of losses and profits cannot be entrusted to one of the partners precisely because of bias. Di ba? If, let's say, for example, akong mag-partners si A, B, and C, si C ang na-assign na mag-establish ng profit and loss, pwede naman na siya, basta mag-consent lahat. Pero kung siya lang, at yun lang decision niya lang, ang masunod, hindi pwede. Okay? Kasi bias yun. Siyempre, siya ang mag-establish ng profit and loss, di siyempre dapat ang profit and loss mas favorable sa kanya. Okay? Let's go to managing partners. The partner who has been appointed manager in the articles of partnership may execute all acts of administration despite the opposition of his partners unless he should act in bad faith and his power is irrevocable without just or lawful cause. Take note that in this article, the manager must be appointed in the articles of partnership. Okay? Kapag na-appoint siya in the articles of partnership, his power is irrevocable. Hindi ka agad ma-revoke. Unless for lawful or just cause or bad faith. Okay? Ngayon, kung yung appointment ng manager is not in the articles of partnership, that anumang acts of administration shall be revocable. It is revocable. Okay? So you should distinguish, Kaya madami ang nalilito sa mga batas-batas kasi mayroong mga specifics na ganito na hindi mo kaagad makikita. Akala mo bla 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 lang. Yun pala, appointed yung manager in the articles of partnership, saka siya magiging irrevocable. Kapag na-appoint yung manager pero wala sa articles of partnership, meaning lahat ng acts niya pwede mong i-revoke. Paano ka magre-revoke? The vote of the partners representing the controlling interest shall be necessary for such revocation of power. So, through votation of the controlling interest. Okay? So, whoever holds a large chunk of the share of the partnership shall have controlling interest in that partner or those partners can call for revocation of power. Okay? So, kapag appointed in the articles of partnership yung manager, generally, his powers are irrevocable unless for just cause or lawful cause or bad faith. But revocation shall only occur through vote of controlling interest. Sir, paano naman yung maliliit lang ang hawak na share sa partnership? 5%, 10%, o baka wala pang 10%. Paano naman sila? Meron ba silang recourse? Yes, there is a recourse. If you are the minority in that situation, you can file for dissolution. Sir, bakit dissolution? Hindi ko naman sinabi na i-end nila yung partnership. But precisely, that is the point. If you no longer have the same interest, okay, kahit pa majority or minority kayo, di ba? Remember, you're acting for the best interest of the partnership, for the community interest. Ngayon, if hindi na talaga kayo magkasundo, at ayaw mo na yung ginagawa ng managing partner, you can file for dissolution. Okay, you can file for dissolution. Para ma-severe na, maalis ka na dun sa partnership, sila na magtuloy, makuha mo na yung just na share mo. Kesa na itutuloy mo pa na ganyan. Okay? So that is the recourse of those holding minority interest. What if there are 2 or more managing partners? Okay? So there are 2 situations. Ito yung unang situation. Kung dalawa, 2 or more ang managing partners, pero dun sa partnership contract, hindi naka-specify yung duties ng bawat isa, or without a stipulation that one of them shall not act without the consent of all the others. Kung walang mga ganun na statements, each managing partner, kahit ilan pang managing partner, may separately execute all acts of administration. Acts of administration to guys, hindi routinary transactions, hindi ordinary business transactions. Kunwari, engage kayo into buying and selling or merchandising, di ba? Yung normal na buy and sell, yun yung normal na operation. Iba yun. Ito kasi, all acts of administration regarding hiring, regarding policies, mga ganun yan. Okay? Each one, kahit sino sa kanila, they can execute all acts of administration. Kasi nga, wala namang specification ng duties. Walang stipulation na one of them shall not act without the consent of the others. But, if any of them should oppose the acts of the others, the decision of the majority shall prevail. So there are rules in play. If there are two or more managing partners, walang specification of duties, walang requirement of consent of all the others, okay, anyone can execute all acts of administration. But, if may nag-oppose, majority of the managing partners. If tie, the matter shall be decided by the partners owning the controlling interest. So, gaya nito, sa example natin, let's say, for example, A, B, and C, sa number 1, A, B, and C are the managing partners. Okay? Ngayon, si A, meron siyang decision or act of administration. And then C oppose that decision. Ngayon, since merong nag-oppose, the majority shall prevail, or the majority decision should be availed of. Ngayon, itong si B, kumampi siya kay A. Therefore, majority A and B against C, majority is A and B. Okay? Now, what if, for example, there's a tie? Proceed tayo sa number 2. What if A, B, C, and D are all managing partners? They are all managing partners. A held a decision, C opposed. Ngayon, majority. B, nag-side siya kay A, si D, nag-side siya kay C. So, majority, wala. Kasi there is a tie. In case of a tie, ang sabi ng batas, whoever has the controlling interest shall prevail. Okay, sino yung may controlling interest? A owns 30%, B owns 15%, that gives you 45%. C owns 40%, D owns 15%, that gives you 55%. In this case, C shall prevail. So, ma-oppose yung act ni A. Okay? Article 1802. Yung kanina, there is no specific duties, there is no stipulation regarding that act of one partner shall not act without the consent of all the others. Okay? Dito naman, if there is a stipulation, in case it should have been stipulated that none of the managing partners shall act without the consent of the others. Ibig sabihin, every act of administration of a managing partner shall be with the consent of the others. The concurrence of all shall be necessary for the validity of the acts. In the absence or disability of any of them cannot be alleged unless there is imminent danger of grave or irreparable injury to the partnership. Okay? Kapag may stipulation na dapat daw may consent lahat ng managing partners sa lahat ng act ng any partner, dapat meron silang consent. Okay? Otherwise, that act is not valid kung walang consent. Okay? Ngayon, hindi rin pwede na hindi mag-consent unless there is imminent danger or grave or irreparable injury to the partnership. Now, let's go to this example. A sold to B, one of the managing partners of partnership X, the other is C, mining claims without consent of C. C opposed that the contract is not binding since he did not consent to the contract. Is the contract binding? C has a point here, di ba? C opposed kasi nga managing partner si B tsaka si C, in-oppose siya kasi wala siyang consent. Sabi niya hindi binding ang contract. Is that true? No. The question is the contract binding? Ano yung contract na yun? The contract between A and B. Okay? si A third party siya, there is no way na malalaman niya na meron palang stipulation na ganun. Diba? So si A in good faith. Therefore, the contract is binding. Dapat ang ginawa ni B, nung nagbenta si A kay B, dapat in-inform niya or disclose niya muna yun kay C. Kasi nga, this stipulation, yung that none of the managing partners shall act without the consent of the others, this stipulation creates an obligation for the managing partners. Ibig sabihin, any acts of administration shall be in concurrence of all the partners. Dapat merong obligation si B na i-disclose yung matter na yun kay C. Okay? However, with that in mind, the contract is still binding because the contract is between A and the partnership. Okay? There is an obligation. With regards to the claim of C against B, that is a different action. Okay? This is not necessary in routine transactions, only in formal and unusual written contracts. Kasi nga, acts of administration ang concern natin, hindi normal operation of business. Okay? Normal operation of business, nandyan naman na yung mga salesperson mo, sila naman ang ang nag-handle dyan. Yung partnership management is iba dun sa operation of business. When the manner of management has not been agreed upon, the following rules shall be observed. Ngayon, we talk about when a manager has been appointed, when two or more managers has been appointed. Ngayon naman, what if walang na-appoint na managing partner? In that case, all the partners shall be considered agents, and whatever any of them may do alone shall bind the partnership without prejudice to the provisions of Article 1801. So in short, all the partners daw will become managing partners. Therefore, if may decision yung isang partner at may nag-oppose, apply mo yung 1801. Ito. Meaning, kapag may nag-oppose, you find for the majority of the managing partners. Kung nag-tie, you refer to the controlling interest. Simple as that. Now, when the manner of management has not been agreed upon, none of the partners may, without the consent of the others, make any important alteration in the immovable property of the partnership, even if it may be useful to the partnership. But if the refusal of consent by the other partners manifests prejudicial to the interest of the partnership, the court's intervention may be sought. Okay? Ito naman, when there is no management agreement, lahat kayo managing partners, anything that involves important alteration in the immovable property, okay, must be made with the consent of all the partners. Why? Because this important alteration in the immovable property is an act of dominion, meaning these are acts exercised by the owner. And the owner of an immovable property of the partnership is the partnership. Diba? And the partnership can only act through its partners. Kaya dapat consent of all partners. Okay? Tandaan, there are two or more managing partners or walang naka-state na managing partners, therefore lahat managing partners. Any important alteration in the immovable property must have consent of all the partners. But if the refusal of consent by the other partners is manifestly prejudicial to the interest of the partnership, the court's intervention may be sought. Ibig sabihin, let's say for example, kailangan nang i-repair yung building kasi baka mag-fall or baka mag-collapse. Okay? Ngayon, itong mga other partners ayaw mag-consent na ipaayos yung building kasi daw magastos. Okay? That is manifestly prejudicial to the partnership. pwedeng pwedeng isik ang intervention ng court. Pwedeng lumapit ang partners concerned dun sa court. Okay? Now, under this article, you have to distinguish between useful and necessary. Useful, kapag useful siya sa partnership, it does not mean that it is necessary. Let's say, for example, yung pag-collapse ng building, that is a necessary alteration. Therefore, kahit walang consent yung partners yan, pwede mong gawin kasi necessary yan. Okay? Ganun yun. Kung useful naman, can be interpreted as profitable or you can benefit, but it is not necessary. Hindi siya necessary for the business. Okay? A, B, and C organize a partnership engaging in transportation business without express authority. A, contracted indebtedness for cash supplies and accessories. Are the partnership and the partners liable for the said indebtedness? Generally, yes, they are liable. Kahit pa walang express authority si A. Why? Because there is a presumption that A has the authority. There is a presumption that A is authorized. So, bakit naman? Sinabi na nga dyan na without express authority. Bakit yung kakontract ba ni A, yung pinagbilhan niya yung pinagutangan niya ng car supplies and accessories, alam ba niya na walang authority, di ba? If the problem is silent, let it be silent. Okay, so the partnership and the partners liable for the said indebtedness. Sub-partnership. Every partner may associate another person with him in his share, but the associate shall not be admitted into partnership without the consent of all the other partners, even if the partner having an associate should be a manager. Ito, mayroong sub-partner. Kaya nakita nyo dyan sa illustration, A, B, and C are partners. Si B nakipag-sub-partner kay D. Ibig sabihin, baka binigyan niya ng right si D na mag-share into profits. But D, as an associate or as a sub-partner, okay, does not become a partner of A, B, and C. So, pwede ba yun? Oo, freedom to contract, di ba? Any person can enter into an agreement with anyone. Okay? Of course, seldom anyone. Of course, siyempre, yung may legal capacity to enter a contract, of course, provided din na lawful yung contract nyo, not against public policy, morals, decency, customs. Okay? Ganun yun. So, pwede yan. Ibig sabihin lang yan, parang naging assignee lang si associate. Hindi siya partner. Okay? Hindi siya pwedeng mag-interfere into business. He does not acquire rights of a partner, nor is he liable for its debts. Pwede kasing ganito yan. Kasi for example, in that illustration, A, B, and C are partners. B has an outstanding debt in favor of D. May utang siya kay D. Ngayon, wala mabayad si B. Ang sabi niya, D, ganito na lang, mag-enter tayo into a contract. Lahat ng profits na ma-receive ko, meron naman akong partnership, kumikita naman. Yung profits na ma-receive ko, sa'yo muna mapupunta hanggang mabayaran buo yung utang. That is sub-partnership. Okay? You're associating your interest with D. Ina-associate mo yung interest mo kay D. Pero ikaw pa rin yung partner. Okay, sub-partner lang siya. That's what you are, sub-partnership. Okay, the partnership books shall be kept subject to any agreement between the parties at the principal place of business of the partnership. Cut tayo dyan. Okay? Saan mag-i-stay ang partnership books? General rule, at the principal place of business of the partnership. Usually kung saan yung office, main office, dun yun. Unless there is an agreement between the partners. Let's say for example, nakalagay sa partnership contract that the partnership book shall always be kept in the house of partner ganito. Kung ganun na nakalagay doon na sa bahay daw ni ganito, makikip yung partnership book, then doon, pwede yun. Ngayon sabi natin, paulit-ulit, kung ano yung stipulation, yun ang masunod as long as it's not contrary to law. And every partner shall at any reasonable hour have access to and may inspect and copy any of them. Take note, every partner, any reasonable hour, when we speak of any reasonable hour, normal hours of operation of the business. So kung daytime yung operation ng business mo, 8 to 9, ay 8 to 5, you can access, you can inspect, you can copy the partnership books. Sir, oras lang ba? No, days, pati day. Kung ang normal operation nyo is Monday to Friday, Monday to Friday. Kung Monday to Saturday, Monday to Saturday. Kung every day you can inspect, access, and copy. Okay? Kung night time ang operation nyo, o kung kailan mag-start yung operation mo, let's say for example, 8 to 7 ng umaga, pwede dun. Okay? Basta at any reasonable hour. Reasonable hour. Another right, tapos tayo dun sa tatlo, right to access partnership books, right to inspect partnership books, right to copy partnership books. Ang consider mo dyan, at any reasonable hour. Partners shall render, the fourth right, partners shall render on demand true and full information of all things affecting the partnership to any partner, legal representative of any deceased partner, or any partner under legal disability. Okay? This is a right of a partner and at the same time, an obligation of a partner. Di ba? Right kasi lahat ng partner, kailangan aware sila sa nangyayari sa partnership. Lahat ng information involving or concerning the partnership, they should be aware. Obligation kasi any partner who acquires notice or knowledge as to partnership information that could benefit that partnership, they have the obligation to disclose that to the partners. Okay? They have the obligation to disclose that to the partners. In this example, A and B are partners. They are engaged in a real estate business. Itong si A, he learned that C is interested in buying a parcel of land owned by the partnership, even for a high price. Oh. Without informing B, A convinced B to sell his interest to A. Then A sold the land at a big profit. Is A liable to B in this case? Tandaan nyo, nabenta na ni B yung share niya kay A. Therefore, parang naging sole proprietor na kasi siya na lang yung partner, si A na lang. Liable pa ba si A kay B? Siya na lang yung partner. Nabenta niya naman yun after nung pag-alis ni A, pag-alis ni B. Liable pa ba si A? Yes, of course. Why? The important thing that you should consider here is the time na nalaman ni A yung information regarding C. Tandaan nyo, si A, nalaman niya yung information regarding the interest ni C sa pagbili ng lupa ng business before na umalis si B. Okay? So, information, dapat at the time na na-acquire ni A yung information, dapat dinisclose niya na kay B. Hindi Hindi niya pa dinisclose. Tapos kinonvince niya pa si B na ibenta sa kanya yung share niya. Binenta ni B, therefore si A na lang yung nasa partnership. Si A naman, sa kanya nabenta yung lupa. Okay? So there is bad faith here. Kasi A did not disclose that information to B. If A would have disclosed that information to B, baka hindi umalis si B. Baka hindi niya binenta yung share niya, di ba? Kasi profit yun. Okay? So in that case, A is still liable to B. Okay? Partners as a trustee. Every partner must account to the partnership for any benefit. Okay? Cut tayo dyan. As simple as that. Every partner must account to the partnership for any benefit and hold as a trustee for it any profits derived by him without the consent of the other partners from any transaction connected with the formation, conduct or liquidation of the partnership, or from any use by him of its property. Lahat ito yung diniscuss natin kanina, di ba? It falls down to here. That the partner is a trustee of the partnership. Kahit anong benefit na ma-derive niya, gaya nung pag-acquire niya ng lupa, yung sabi natin kanina, na naghahanap ng lupa yung partnership, imbes na sinabi niya sa partnership, siya yung bumili, that is also acting as a trustee. Okay? So kahit pa dun sa formation, sabi dito, from any transaction connected with the formation, conduct, or liquidation. Dun sa formation ng partnership, let's say for example, the partners wanted to conduct a feasibility study, a presentation before they will push through with the partnership. Therefore, you need money to conduct feasibility study and to make that presentation. During those instances, nakakuha ka ng discounts sa nag-conduct ng feasibility study and presentation. Yung discount na yun, imbes na binalik mo sa partnership, tinago mo, ginamit mo para sa'yo, that is, liable ka pa rin. You must always account that to the partnership. So, babalik mo lahat yan. Worst case, you will be liable for interest and damages pag na-found out. Conduct, yung baka may mga sales ka na kinoconceal or transactions na hindi mo sinasabi sa partnership, di ba? Or sa liquidation, imbes na yung property can be sold or liquidated at a higher price, pinili mo yung at a lower price, tapos yung cut mo na lang, kinuha mo, di ba? You will account that to the partnership. Any partner shall have the right to a formal account as to partnership affairs. Ngayon, this pertains to suit for accounting or an action for accounting. Kailan? If a partner is wrongfully excluded from the partnership business or possession of its property by his co-partners. Of course, if you are wrongfully excluded from the partnership business, partner ka dun eh. Diba? Sabi natin kanina, you have the right to full disclosure of information. You can access the partnership books, inspect and copy the same within any reasonable hour, diba? If that right is denied to you, you can ask for formal accounting. Kasi baka may mga nangyayari na sa partnership na tinatago sa'yo. Di ba? And you're a partner, you should have the right, di ba? You're concerned with that. Usually kapag ganyan na nagde-demand na sila for accounting, it is followed by an action for dissolution. Siyempre, in-exclude ka na sa partnership business. Hindi ka na sinisharean sa partnership property, di ba? Eventually, it will go for dissolution. If the right exists under the terms of any agreement, so, if let's say for example, yearly may accounting or semi-annually, pwede, as provided by Article 1807, okay, kapag merong mga benefits or profits na hindi na-account sa partnership, you can make an account for that. Whenever other circumstances renders it just and reasonable, usually a demand for accounting or a suit for accounting is only filed during or after dissolution. Okay? Sabi dito, only when partnership is dissolved, not for principal business transactions. So, ang suit for accounting is usually during dissolution or after dissolution. So, ganyan instances when you can ask for accounting or you can demand for accounting. Wrongfully excluded from the partnership business or possession of its property, or if it's stipulated in the agreement as provided by Article 1807, when you demand for an account based on unaccounted benefits or profits, whenever other circumstances renders it just and reasonable. Let's go to property rights of a partner. Property rights. There are three types of property rights. The first one, rights in a specific partnership property, his interest in the partnership, and rights to participate in the management. His rights in the specific partnership property. First, you have to determine always whether the partnership property is really contributed to the partnership. Whether the ownership is really transferred to the partnership. Kasi kung ang use lang ang na-contribute, yung partner pa rin ang may-ari dyan. If na-contribute talaga yung property, lahat kayong partners, you are co-owners of that partnership property. A partner has an equal right to possession. Why? Because you are the co-owner, which is not assignable. That right to possess is not assignable by one partner unless all the partners consent to assign that property. Okay? Kasi nga, act of dominion, balik tayo na naman dun, regarding property, act of ownership, kapag pagmamayari ng partnership, all the partners must consent. Okay? Why? To prevent outsiders in partnership affairs. And such right is limited to the share of what remains after partnership debts have been paid. Meaning that the partnership property shall be subject to partnership credit. Let's say for example, nag-end na yung term, di-dissolve na, magli-liquidate na, meron kayong existing outstanding obligations. Kung naubos na yung pera nyo, pera ng partnership, they will go for the partnership property. Kung naubos na kung ano man yung matira dun sa partnership property, yun yung paghahatian ng partners. Kung wala. Okay? The partnership property shall not be subject to attachment or execution, mainly because the partnership, it is already partnership property, hindi na siya property nung tao, nung partner. Okay? Except a claim against partnership, of course, gaya ng in-explain ko kanina. Partnership property is liable to partnership creditors. It is also not subject to legal support. Why? Because it is no longer partnership property. Legal support kasi, yan po yung support na legally obliged yung husband and wife to support their children or to support each other. Okay po. Yung interest in the partnership, the interest in the partnership consists of two. The profit and the surplus. The profit is your net income. It's the return over the expenses. Your surplus is the excess of assets over liabilities. Tandaan nyo ito Ang interest, dalawa, profits and surplus. Okay? And then the third property right is the right to participate in the management. Assignment of interest. Itong interest na to, yung right to share in the profits and surplus. Okay? I hope that's clear. Paano mo i-assign? It must be made in good faith, for fair consideration, and after a fair and complete disclosure of all important information as to value. So, 3 conditions. You can assign your profit and surplus. Okay? Anong rights ng assignee? O parang ito yung kanina yung sa sub-partner o yung associate. Kung ano yung right ng assignor or yung partner, ma-obtain ng assignee. With regards to right to share in the profits and in the surplus. Yun lang They don't have the right to interfere in the management. They are not partners. They do not have the right to inspect, to copy, or access the partnership books. They are not partners. Okay? Avail usual remedies in case of fraud. Of course, if there is fraud. If sabi niya meron siyang share sa partnership, pero nasabi niya na he owns 50% share in the partnership, kaya nangyari na hindi pala 50%, 10% lang, he can sue. Also for the annulment of contract of assignment. If there is fraud or vice in the consent. Ito lang din yung right na matanggap niya. So, the right to share in the profits, in the surplus, and the right to demand an accounting in case of dissolution. So, the assignee does not become a partner. Sir, pwede bang maging partner yung assignee? Yes, in case there is a consent of all the other partners. But generally, the assignee of an interest does not become a partner. Charging order. Without prejudice to the preferred rights of partnership, creditors under Article 1827. So, without prejudice daw sa Article 1827, on due application to a competent court by any judgment, creditor of a partner, the court which entered the judgment or any other court may charge the interest of the debtor partner with payment of the unsatisfied amount of such judgment debt with interest thereon, and may then or later appoint a receiver of his share of the profits and of any other money due or to fall due to him in respect of the partnership, and make all orders, directions, accounts, and inquiries which the debtor partner might have made or which the circumstances of the case may require. So, ang ibig sabihin lang dito, guys, that there was that a partner is indebted to a personal creditor. Ibig sabihin, ang sabi niya, on due application to a competent court by any judgment creditor of a partner. So, personal creditor ng partner. Lumapit daw siya sa court at nag-ask siya na yung interest daw nung partner is ma-charge. Why? Basically, baka insolvent na yung partner. Okay? Gaya nito, A, B, and C. A is personally liable to X in the sum of 5,000 pesos. So, si A daw na partner ng A, B, and C, may utang daw siya kay X. So, personal creditor ito. Ngayon, itong si X, hindi niya na makolekta si A. Nalaman niya na mayroong partnership si A. Okay? Kinasuhan ngayon ni X si A. Anong kinaso ni X kay A? Collection for sum of money. Kasi may utang nga siya kay A. Ngayon, naglabas na ng judgment yung court. Nanalo si X. Ngayon, X, kaya ang sabi dito, judgment creditor, di ba? Nanalo si X, may judgment, nanalo si X. Ngayon, X can ask the court to issue a charging order against the partnership for the payment of debt of A. Ibig sabihin na ito, itong charging order, imbes na si A ang makareceive ng shares in the profits and surplus of the assets over liabilities, si X nang magre-receive by virtue of the order of the court. However, take note, this does not apply if there is a partnership creditor. Pwede lang itong charging order if there is no partnership creditor. Kapag may partnership creditor kasi, mauuna mo nang isatisfy yung partnership creditor. Kapag nasatisfy lahat ng partnership creditor at may natira pa sa interest ng partners dun sa partnership, dun pwede na yung charging order. Ngayon, if ayaw naman ng partnership na ma-charge yung interest ni A, may pwede ba silang gawin? Yes. They can, with separate property by any one or more of the partners. Ibig sabihin, kung gusto nilang i-offer yung separate properties nila. Of course, hindi na pwede si A kasi wala na siyang properties. Diba? Kaya nga, ang resort ng X is dun sa partnership na. Kung gusto ni B and C, yung separate properties nila para hindi ma-charge yung partnership. Or, with partnership property but must be with the consent of all the partners. Ngayon, kung ayaw nilang ma-charge yung interest ni A, pwede namang, let's say for example, pag meron pang partnership property, meron pang pwedeng i-dispose, pwede yun. But this one right here, kasi partnership property yan, subject pa rin siya sa partnership creditor. Kung may partnership creditor, mauna yun. Kapag naubos na yung partnership creditor, na-satisfy lahat, at may natira pa sa assets, pwede pang i-charge. Okay? So, yun yung charging order. In short, merong recourse yung nagpautang kay A. Okay? Kahit pa insolvent na siya. Pwede niyang i-charge yung interest ni A. Okay? Tandaan niyo yung definition ng interest, ha? Ulit-ulit yun. Share in the profits and surplus. Obligation to third persons. Okay? Every partnership shall operate under a firm name. Okay? Persons who include their names in the partnership name, even if they are not members, shall be liable as partner. Of course, kung sinali mo yung pangalan mo dyan, di partner by estopel ka na. Bakit? You represented yourself to be a partner. Therefore, pag nagkautang yung partnership na yan, at nagkandaloko-loko, at tinabol silang lahat, nandun yung pangalan mo, kasama ka dyan. Okay? Ngayon, this partnerships with that operates under a firm name that uses the name of their partners, usually sa mga CPA firms or sa mga law firms. Okay, gaya ng SGV, gano'n, di ba? Ngayon, let's say for example that a partner, yung apelido niya doon, namatay na, liable pa rin ba siya in case na may mga liabilities ang partnership? Hindi na. Okay? Hindi na as long as it is indicated that that partner is already dead or deceased or has already retired from the partnership. Saan mo i-indicate, sir? Sa partnership contract? No. Sa lahat ng contracts nila with their clients, with their suppliers. Why? To give notice na this partner na ginagamit namin yung firm name is already dead or deceased or retired. Okay? So, if retired na, dead or deceased, bakit di na lang tanggalin sa partnership firm name? Diba? O if that happens, usually kasi yung mga partnership na operating under those names, kaya ng mga sikat na mga CPA and law firms, okay, they already acquired goodwill. Alam nyo naman yung goodwill, di ba? Meron na silang reputation. Benta na sila, di ba? Goodwill, parang Toyota, Jollibee, di ba? Kahit pa siguro walang magbago sa mga products nila, 10 years from now, madami pa rin bibili niyan because of their reputation. Ganun kasi sa mga CPA and law firms. Kaya, as much as possible, nire-retain nila yung name para as long as makita ng tao na ito yun, lalapit at lalapit sila. It's the goodwill of the partnership. All partners, including industrial, shall be liable for contractual obligations of the partnership with their property after all assets have been exhausted. After all partnership assets have been exhausted. Ngayon, you should not be confused with regards to net loss and capital loss or for contractual obligations contracted. Kasi ang sabi natin kanina, with regards to net loss, the industrial partner shall not be liable. That's true. Net loss yun. Pero kung contractual obligation or capital loss, the industrial partner can be liable. Anong liability nila? Pati yung lahat ng partners pro rata or in proportion. Okay? And subsidiary din yung liability. Meaning that the primary liability falls on the partnership. Meaning, yung partnership assets, gaya ng diniscuss din natin kanina if you can remember. Partnership assets are liable for partnership liabilities. Pag na-exhaust, naubos mo yung partnership assets at meron pa ring partnership liability, doon na magiging liable lahat ng partners sa kanilang separate properties doon sa loss. So kahit pa industrial partner siya, magko-contribute pa rin siya. Okay? Iba yung net loss, baka gumugulo yung net loss eh. Okay, iba yun. Of course, you take note din naman na hindi kasali dito ang limited partner. Kasi, di ba, as in our first topic, ang limited partner liable only up to the extent of their contribution. So, we're talking about capital partner or industrial partner. Okay? or general partner usually. Under obligations to third persons pa rin, admission or representation made by any partner concerning partnership affairs within the scope of his authority is evidence against the partnership. This was, of course, falling pa rin under partner by estopel. As long as there are admissions, acts, representations by any partner. Ito kasi, madaming kasing klase ng partner by estopel. Ito kasi within scope of his authority. Kung may misrepresentation siya sa ibang third persons regarding the partnership and that is within his authority, that is already an evidence against the partnership. Partner by estopel siya. Okay? Okay, take note, notice to partner, any notice to partner is notice to the partnership. Okay? Any notice to the partner is notice to the partnership. Kaya nga sabi natin kanina, any information na masasagap ng partners, they have the obligation to disclose those information to their partners. Hindi nila pwedeng i-conceal yun. Tapos later on, magte-take advantage sila. No? Ano yung mga notice na to? Hindi lang notice, knowledge of a partner acting the particular matter acquired while a partner. Of course, while he is a partner, any knowledge acquired by him is a knowledge of the partnership. Knowledge of the partner acting in the particular matter then present to his mind. So, even before he became a partner, any knowledge by him regarding that particular matter is knowledge of the partnership. Kasi, there is a great possibility na yung knowledge niya kahit wala pang partnership, prior partnership, kapag bumuo sila ng partnership, madidiscuss yung knowledge na yun regarding that particular matter. Okay? Knowledge of any other partner which reasonably could and should have communicated it to the acting partner. Okay? Except, of course, in cases of fraud committed by or with consent of that partner. Take note, except in cases of fraud. Partners and the partnership are solidarily liable to third persons for the partner's tort or breach of trust for everything chargeable to the partnership. Of course, na-discuss na rin natin kanina, you can relate it there, that any damage caused by the partners, they shall be liable. Okay? But, if that damage relates to third person, okay, to third persons, the partners and the partnership shall be liable. In case of tort, breach of trust, fraud, everything is chargeable to the partnership. Which is, kapag sinabi mong partnership, the partners themselves. Now, still in liability of incoming partners, you have to distinguish here din. Okay? Liability of incoming partner is limited to his share in the partnership property for existing obligations, his separate property for subsequent obligations. Take note, let's say for example, let me try to use paint. Okay, let's say for example, A and B are established partnership already. Ngayon, itong si A and B, merong present obligations amounting to 50,000. Pagpasensyahan nyo ng sulat. Okay? Yan yung unang nangyari. Ngayon, C joined the partnership of A and B. Okay, C joined the partnership of A and B. At the time na sumali si C kay A and B, meron utang na 50K. Okay? Ngayon, merong contribution si C in the amount of, let's say for example, 10,000. Meron siyang contributions in the amount of 10,000. Ngayon, ang question, is C liable to the existing obligation of partnership ni A tsaka B bago siya pumasok? Liable ba siya dun sa existing obligation na yun? The answer is yes, liable siya. Liable siya but only to the extent of his share. So, up to 10,000 lang po ang liability niya. Now, going on with the problem, hindi ko makita yung mouse ko. Ayun. Going on with the problem, let's say for example, since nag-join na si C, nag-incur sila ng additional or subsequent obligations amounting to 100,000. Okay? In this part, liable na si C up to the extent of his separate property. Okay? So, you have to take note of the distinction. So, C and B, before na sumali si C, merong 50K na utang. Ngayong sumali si C, nag-share siya ng 10,000. Liable ba si C dun sa 50K? Yes, only up to the extent of 10,000. Hindi siya liable to the extent of his separate property. So, yung separate property niya, safe. With regards to the 50K na utang. Ngayon, kapag nag-incur yung partnership ni A, B, and C ng 100K na additional na utang, liable na ba si C dun sa separate property? Yes. C is already liable for the partnership obligations with regards his separate property. Creditors of partnership preferred in, of course, paulit-ulit to, 3, 4 na beses na sabi, partnership asset or partnership property is liable for the creditors of the partnership. Creditors of partners may attach partner share in partnership assets. Ito na yung charging orders. However, subject to this provision, kapag merong pang partnership creditor silang mauna. Kahit merong personal na utang yung mga partners sa mga ibang tao, ang laging mauna is partnership creditor. Ngayon, kung ang concern is partners assets, yung separate property niya, of course, ang merong preference naman dyan is yung separate creditors niya, hindi partnership creditor. Okay? Every partner is an agent of the partnership. I would like to elaborate on this one. Ito. I-elaborate natin yung concept na yun. Paano ito i-clear? Ay, Joe. Ay, don't save. Okay. Paano yun? Pag partnership property and separate property of partners. Okay? I hope you can relate. Kung partnership property, mauna ang partnership creditors. Dapat masatisfy mo na yung pautang nila. Saka mo pwedeng bigyan yung separate creditors ng partners. Okay? Kapag separate property of the partners, naman, mauna ang separate creditors, di ba? Saka mo i-entertain yung partnership creditors. Kasi separate property ito ng partner eh. Ito, partnership property. Kaya ang preference partnership creditors. Okay? I hope that's clear. Okay. Every partner is an agent of the partnership. Of course, every partner acts for the benefit of the partnership. Saying that, okay, there are limitations as to that. If that act pertains to the usual business of the partnership, okay, that act may bind the partnership. So, every partner is an agent and may execute acts with binding effect. Take note, these are usual way of the business, yung mga routinary, yung mga normal operation of business. Except when third person has knowledge of lack of authority or in fact has no authority. Okay? Kapag yung third person, alam niya pala na walang authority yung partner, hindi magbabind. Or kapag wala talagang authority yung partner, hindi magbabind. Pero general rule, binding. Okay? Binding. Kapag yung act naman is not in the usual way of carrying the business, of course, it does not bind the partnership unless they have the authority. Okay? And these acts of strict dominion or ownership, di ba, pag nandyan, kailangan ng consent ng lahat, alam nyo na yan. Assigned partnership property and transfer creditors, same, act of dominion kasi yan. Dispose goodwill, do an act which would make it impossible to carry on ordinary business of partnership, confess a judgment, enter into compromise, settlements, submit partnership claim or liability to arbitration, renounce claim of partnership. Any of these acts will not bind the partnership unless siya yung managing partner or they have the authority or they have abandoned the partnership. Okay? So, general rule, ang acts lang na magbabind sa partnership is acts that are in the usual way of business. Okay? So, acts in contravention of a restriction on authority, partnership is not liable to third persons having actual or presumptive knowledge to the restriction. So, in short, acts in contravention of, let's say for example, merong two or more managing partners, they have their own specific duties, they have their own restrictions as to their authorities. Now, nakipag-transact sila. Let's say, for example, one of those managing partners entered into a contract or transaction with a third person. Necessarily, that contract is binding. Lagi kong sinasabi kanina, binding yan. Unless maipakita na yung third person na yun has knowledge. Basta ang laging defense actually is bad faith. Bad faith. Okay? Paano yung bad faith? Kung alam nung third person na yun na in contravention of his authority na pala yun or on the restriction of his authority. Limited lang pala yung authority nung managing partner na yun. Alam nung third person, it will not bind the partnership. Pero kung hindi alam nung third person, it will bind the partnership. Now, let's go to conveyance of real property belonging to partnership. Take note, we're talking about real property. If the title is in the partnership name, so kung ang title is nasa partnership name, therefore, the partnership owns the real property. And the conveyance or yung transfer is in partnership name, of course, it will pass title. Meaning that the ownership will pass. Okay? Conveyance to. Either binenta, okay, dinonate. Ganun po yun. The title will pass. But, partnership can recover if conveyance was not in the usual way of business. Okay? Buyer had knowledge of lack of authority. Okay? So, general rule, if it's if the real property is in the partnership name and conveyed in partnership name, the title will pass, the ownership will pass to the buyer or to the donee kung ano man yung nangyari. But to do this kasi, you need the consent of all the partners. Or, you must have the authority to sell or authority to donate these properties. Kung wala, the partnership can recover. What if the title is in partnership name, therefore, ang may-ari daw is partnership. Conveyance in partner's name. Pero ang nagbenta is partner. Will the title pass? No. The title will not pass or the ownership will not pass. Only equitable interest. Only equitable interest provided within authority. Unless, same grounds, conveyance was not in the usual way of business or buyer had knowledge in lack of authority. Bakit nag-pass pa rin, sir, yung equitable interest? Kasi nga, you're talking about conveyance, binenta or dinonate sa third person. Itong third person na to, he has no way of knowing whether you had the authority, di ba? Or whether your act is consented by the partners. Kaya meron pa ring equitable interest na magpapasa sa kanya. Okay? Okay. Kaya, pero hindi yung title. Title is in the name of one or more partners. So, this is not partnership property. Conveyance in name of one or more partners, kung kanino yung title daw. So, of course, kung sila yung may-ari, sila din yung nag-convey, yun lang naman yung rule eh. Kung sino yung may-ari, dapat siya yung mag-convey. Kung sila din yung nag-convey, of course, title will pass. Pero, partnership can recover if conveyance was not the usual way of business, buyer had knowledge or lack of authority. So, take note, whoever is the owner, sinabi ko na to kanina, whoever is the owner has the right to convey. Kasi hindi mo naman pwedeng i-convey yung property na hindi sa'yo. Diba? Ganun lang ito. Title in the name of one or more or all partners or third person in trust for partnership. Conveyance executed in partnership name, if in name of partners. Conveyance will pass equitable interest provided within authority. Okay? Equitable interest lang ito. Why? Because the persons who own the real property is not the partnership, but the partners or third persons, but it was conveyed by the partnership. Okay? Equitable interest lang po siya. Okay? What if the title is owned by all the partners, so co-owners daw yung partners, and conveyed by all the partners? Of course, it will pass the title. So, kung mapapansin nyo dito, kung nakadino yung title, kanino nakapangalan yun, siya yung may-ari, siya lang din dapat ang mag-convey para mapass yung title, as simple as that. If hindi yung nakapangalan or if hindi yung owner ang nag-pass or nag-convey ng title, no title will pass. Only equitable interest. Why? Because you are transacting with a third person who has no way of knowing that your act is authorized or not. Diba? Ganun. Malapit na. Misapplication. The partnership is bound to make good the loss. Number 1, where one partner acting within the scope of his apparent authority receives money or property of a third person and misapplies it. Let's say, for example, the cashier or the managing partner who receives all the remittances from the cashiers, okay, when he acted within the scope of his apparent authority, okay, of course, kapag cashier ka, ikaw mag-receive ng bayad sa customers. Kapag managing partner ka, sa iyo magre-remit ang mga cashiers, tapos na misapply mo yung pera na yun, whether na misappropriate mo, nagamit mo sa ibang bagay, okay, the partnership is bound to make good of it. Let's say, for example, yung partners, yung money na niremit sa'yo, let's say for example, A is the managing partner and the money has been remitted in the amount of 50,000 by a third person. Kunwari, it was held only in trust by the partnership. Okay? Therefore, the partnership has the obligation to return that. And in that instance, na misapply or na misappropriate ng isang partner, the partnership will be liable to the third person. Okay? But the partnership, they can reimburse from the partner who misapplied it. Gets nyo? Si third person, nagpahawak ng pera kay partnership. Ang nag-act in behalf of his apparent authority for the partnership, let's say is A. Let's say it's A. Si A ang nag-receive ng money kay third person. Okay? Kay third person. Ngayon, ang contract or ang obligation is really with partnership and third person. Therefore, the partnership is bound to make good the loss in case na mawala yun. Of course, may recourse ang partnership, pwede nilang habulin si A na nag-misapply o nag-misappropriate nun. Okay? I hope you get that. Where the partnership in the course of its business receives money or property of a third person, and the money or property so received is misapplied by any partner while it is in the custody of the partnership. Okay? Okay, ay ito na yung sinabi ko kanina. Okay? Where the partner receives money or property of a third person and the money or property so received is misapplied by any partner while it is in the custody of the partnership. Okay? As long as it is in the custody or the partner is acting within his apparent authority, anything na mahawakan nila na money or property ng third person, okay, the partnership will be liable to the third person. Don't discount the fact na itong partnership na to, although liable sa third person, itong partnership na to, pwede niya pa rin habulin si partner, yung mismong nag-misapply or nag-misappropriate ng fund. So that is misapplication. And then the last part of rights and obligations of partners, partnership by estoppel. So if you read, pag nabasa niyo buong yung libro, mahaba talaga to. When a person by words is spoken, take note, words is spoken, written, or by conduct. So ito yung representation niya. Nagsabi siya, contracts or written, or by conduct, represents himself or consents to another representing him to anyone as a partner in an existing partnership or with one or more partners, not actual partners. So, when a person, sabi niya, so hindi partner. When a person, hindi partner, ni-represent niya na partner siya sa existing partnership or with one or more persons or dun sa hindi partnership. Liable yung person na yun to any such persons to whom such representation has been made, who has, on the faith of such representation, given credit to the actual or apparent partnership. And if he has made such representation or consented to its being made in a public manner, he is liable to such person whether the representation has or has not been made or communicated to such person, so giving credit by or with the knowledge of the apparent partner making the representation or consenting to its being made. When a partnership liability results, he is liable as though he were an actual member of the partnership. When no partnership liability results, he is liable pro rata with the other persons, if any, so consenting to the contract or representation as to incur liability, otherwise separately. Meaning, when a person misrepresents himself to be a partner in an existing partnership, or kung wala man lang partnership, liable siya dun sa person na nag-rely on that representation, on the faith of such representation, okay, liable siya dun. Yun yung tinatawag nating partner by estoppel. Represents himself as a partner. Ibang partner by estoppel sa partnership by estoppel. Siya, yung person na yun, is partner by estoppel. Ngayon, sabi natin kanina, merong existing partnership or with one or more persons, not actual partnership. So, dalawang situation. May existing partnership, meron yung walang partnership talaga. So, if dun sa walang partnership talaga, pero ni-represent niya na merong partnership, ang mabubuo is partnership by estoppel. Let's say for example, A, B, and C, magbabarkada. Si D, nakaisip ng racket. Sabi niya dun sa tatlo, i-introduce, meron akong prospect client, and I will introduce myself as a partner. Tayong apat magpa-partner na meron tayong partnership. Okay? Kapag nag-rely yung third person on those misrepresentation and actual credit or money has been received by the partnership, they are liable as a partnership by estoppel. Okay? Lahat sila. Silang apat. Take note, walang partnership yun ha. Nag-usap-usap lang sila. Hindi sila nag-object dun sa representation ng isang partner. Ngayon, if there is a partnership, but everyone consented to the one who is not, partnership by estoppel pa rin yun. Paano? Let's say for example, A, B, and C. This time, A, B, and C are actual partners in a partnership called X. So, meron talaga silang partnership. Ngayon, lumapit sa kanila si D. Sabi ni D, meron akong prospect client, pwede tayong makakuha ng funds. Pwede ko bang i-represent or sabihin sa kanya na kasama ako sa partnership nyo? If walang umimik, pumayag lahat, and after that, nag-benefit kayo, nakakuha kayo ng funds, the whole partnership is liable. Okay? Plus the partner. Itong partner na to na laging nagre-represent, siya yung tinatawag nating partner by estoppel. Okay? Huwag kayong malito dyan ha. Yung tao na laging nagre-represent, parang nanggagancho, ganun ba? Siya yung partner by estoppel. Yung nabubuo dyan is partnership by estoppel. Okay? Estoppel guys, to shed light further, estoppel kasi is a bar to any admission or representation made. Ni-represent mo na or pinakilala mo na yung sarili mo na partner, hindi mo na siya pwedeng i-deny. You are barred to deny it. Yun ang estoppel. You are stopped. Okay? So that is what you call partnership by estoppel. But you read the last phrase, but in all other cases, it is the joint act or obligation of the person acting and the persons consenting to the representation that is that constitutes partnership by estoppel. So hindi lang yung act nung tao na nagrepresent as partner, but by the consent of the persons involved, whether there is an existing partnership or there is no partnership at all, basta nag-consent sila, they will all be liable. Okay? So that is partner by estoppel.